Welcome back to Legal Lens Zimbabwe, where we make the law less intimidating and more, well, entertaining. Today we're diving into the law of delict, specifically the first ingredient in our legal stew, conduct under the Aquilian action. And trust me, this one's juicy. Ever wondered if you can be held liable for something you did while blackout drunk or during an epileptic fit? Let's find out. In the Aquilian action, we've got 6 key ingredients. 1. Voluntary conduct. 2. Wrongfulness. 3. Capacity. 4. Fault. 5. Causation. 6. Loss. Today, we're cooking with the first one, voluntary conduct. Now, don't confuse this with just doing something. The law wants to know, did you do it with your mind switched on? Voluntary conduct means your body was under the control of your conscious will. You were compos mentis, of sound mind and sober senses. Let's take a classic example. Imagine Mr. Moyo, who has epilepsy, decides to drive from Harare to Masvingo without taking his meds. Halfway through, he blacks out and crashes into a combi full of passengers. Can he be held liable? Well, yes, because the conduct that set the causal train in motion was voluntary. He knew his condition, chose to drive, and failed to take precautions. That's where the law says, Mr. Moyo, you should have foreseen the harm. In Wessels and Ainer v. Pickles, the defendant was found guilty of negligence. While driving, he had suffered a diabetic coma due to low blood sugar. He had suffered a previous attack resulting in an accident. He knew his condition and how to control it even if not been told by his doctor. The circumstance at the time of the defendant's preceding voluntary conduct must have been such that a reasonable person would have foreseen the possibility of harm to another and would have taken precautions against it. In the criminal case of S.V. Rensburg, the accused had had blood tests, which had led to a fall in his blood sugar levels. His doctor did not warn him that this might happen, and it was not reasonably foreseeable. X was thus not responsible for the accident and found not guilty of negligence. That's called automatism, a defense that says, my body acted, but I didn't. S.V. Bartman, where X becomes intoxicated or uses a drug with the intention to injure Y when he is later unable to control himself. More so, the defense does not apply where he was negligent with regard to his automatic conduct. In Malef v. Mahan, the court held that there was no evidence that a reasonable person in the position of the defendant would have been aware of the possible blackout while driving the car. Arvim Kais, where X, during an epileptic fit, stabbed and killed his sister. The court held that it was clear that the act happened while the accused was unconscious had he did not do a voluntary act. Absolute compulsion, where X pushes a knife into Y's hand and then, without Y being able to offer resistance, takes hold of the hand holding the knife and forces it into ZS chest. Now, let's talk about conduct that's not physical. What if you say something that causes harm? Like telling someone their combi is cursed and they crash trying to exorcise it. Words can be conduct too, but the law says, easy there, Shakespeare. Words are more volatile than deeds, so liability is limited unless there's a duty to speak responsibly. Hedley Byrne v. Heller. The court stated that misstatements can be delictual if there's a duty of care. Here's the twist. The law doesn't expect you to be a walking Jesus. You're not liable for every time you fail to act, unless there's a legal duty to do so. If you had a duty to help, like a lifeguard ignoring a drowning swimmer, you could be liable for your omission. In summary, voluntary conduct means your brain was in charge. If your body was moving like a combi with no driver, sorry, the law says that's not your fault. Unless you chose to be the combi with no driver, then well, Houston, we have a problem. Automatism is when your body goes rogue, like your uncle at a wedding after 3 rounds of ZD. He's dancing, he's singing, he's proposing to the DJ, but legally, he's not in control. The law doesn't expect you to be a walking Jesus. You're not legally required to heal the sick, raise the dead, or fix your neighbor's broken borehole unless you had a duty to act. So relax, you're not the Messiah, unless you signed a contract saying you are. And on foreseeability, well, if you know you get blackout drunk after 2 rounds of chibuku and you still decide to drive, that's not just bad judgment, that's legally asking for a lawsuit. The law doesn't do YOLO. Yes, Words can be conduct too. But don't worry, calling your cousin's business a scam on WhatsApp won't land you in court, unless you're a banker giving financial advice. Then it's not gossip, it's delict. Reflex actions don't count. So if someone scares you and you karate chop them like Bruce Lee, don't panic. Unless you plan the chop. Then you're not Bruce Lee, you're legally liable. So, next time you're tempted to drive while sick or say something wild on WhatsApp, remember, the law is watching your conduct, and it wants you awake, aware, and responsible. Subscribe to Just Legal Zimbabwe for more legal wisdom with a twist of fun. And as always, stay legally woke. See you in the next episode, where we tackle wrongfulness, and trust me, it's not just about being rude.